If you're watching this, you're likely feeling the weight of a life in transition. You're wondering, what happens to my house? How do I protect my relationship with my children? Will I be financially secure when the dust settles? Most people enter the divorce process feeling like they're walking through a storm without a map. But here is the truth. You have rights, powerful legal rights designed to ensure your future isn't just left to chance. Today, we're moving on from uncertainty to clarity. I'm going to show you exactly what you're legally entitled to. Welcome. I'm Danielle Joseph Key, and at the Legal Assistance Center, we've spent over 2 decades providing strategic, results driven advocacy for families navigating their most difficult chapters. This is a deep dive into your rights in divorce. We aren't just talking about fairness, we're talking about the unmatched protection the law provides for your property, your children, and your peace of mind. So let's get started. First, let's talk about your assets. You have the right to an equitable distribution of marital property. Now, equitable distribution does not mean equal distribution. What equitable distribution means in the state of New Jersey is a division of assets that is most fair under the circumstances. In a lot of states, that means 50-50, but in New Jersey, sometimes that means 60-40, 80-20, 75-25. The courts look at the details of your marriage to determine what is the most fair split of the assets. So what does that mean for you? It means that anything acquired during the marriage, the home that you purchased or built, the cars that you drive, the savings accounts, even the debt, IRS debt, medical debt, credit card debt, all of that is subject to division. All of that is on the table and part of what's colloquially known as the marital pie. Also included in that marital pie are the retirement accounts. Now, retirement accounts does not mean that if you didn't work, you get nothing. Marriage is a contract. Everything that was acquired during your marriage in the event of a divorce is subject to distribution. So the retirement account is not about who earned it. It's about when it was earned. From the date of marriage to the date of filing your divorce complaint, the increase in value in that account can be subject to distribution. What increased in value before you married is not subject to distribution. If you are one of these people that, and it's happened, I've had clients, I've done this over 20 years. I've had clients say to me, oh, but Danielle, we were together for 20 years. I understand that. But you only married for 5. So the division of the assets with respect to retirement assets is only from the date of marriage. So no, you don't get 20 years worth of a division if you were only married for 5. That sounds harsh, but that's the law. And how do you get division of those assets? Well, at the end of the divorce, you will probably have to do what's called a quadro, a qualified domestic relations order. That's the legal tool that's used to ensure that you receive your portion of your spouse's 401k or pension without tax penalties. Now, while separate property like an inheritance or something you own before the wedding, as I said before, often stays with you unless it's commingled during the marriage. The quadro is used to make sure that the division of the asset is what you are legally entitled to receive. So the pension appraisers that determine the quadro use a formula called the marital coverture fraction. It's a numbers game. It is what it is. It's the number of years married over the amount of the pension or 401k at the start of the marriage, the amount of the pension or 401k when the divorce is filed, divided by the number of years of marriage, and out comes a number. That is what you will receive. And that quadro does come with a cost that's typically split 50-50, and needs to be done within 6 months of the divorce. The other aspect, as most people know about divorce, is alimony. Alimony is called alimony once you're divorced. If you are receiving money from your spouse to support yourself while you're still married, that is referred to as spousal support. Every divorce does not result in alimony. You always have the right to seek spousal support, which is support from your spouse while you are married. That includes while you are going through the divorce process itself. If your spouse was the higher earner and typically supported you, your spouse has the legal obligation to continue that support until the divorce is finalized. After the divorce, now there are factors the court have to consider, because once you are divorced, there's no longer the duty to support. There are individual alimony factors that the court looks at to determine what, if any, alimony will be received. And alimony is not a handout. It is a legal recognition of the partnership that you lived. If there isn't a significant income gap, or if you sacrificed your career to support the family, then alimony will and is designed to help you get back on your feet. The court looks at several factors in determining alimony: the length of your marriage, your earning capacity, your health, your educational background, whether it's rehabilitative support, which is the alimony to get you back on your feet, typically to help you go back to school and get a degree that will allow you to get either a better paying job or get back into the workforce if you've been out of the workforce. Or if it's open durational alimony, what used to be called permanent alimony, which is alimony that's used typically for longer marriages. You're married 15 years, 20 years, 25 years. Open durational support. You have the right to ask the court for the alimony to ensure you are not left in a financial lurch. And an attorney, such as myself, can explain to you the type of alimony that would be most appropriate for your situation, or even the likelihood, the extent to which you would receive that alimony. Also, in a divorce, if there are children under the age of 18, custody and parenting time are major issues in the divorce. To make your divorce as simple as possible, I always tell my clients it's easier to resolve the custody and parenting time issues before you file for divorce, because nothing will lengthen the length and cost of your divorce like fighting about custody and child support. But that is not always possible. Okay. And that's recognized. As an attorney, I understand that custody and parenting time issues are highly emotional. And the reason that you need an attorney in a family case is not because you can't do the family case yourself. 90% of people could represent themselves in family court quite well. Why you need an attorney to have the distance, the emotional distance from the case, to ensure that you get all that you deserve. Because when you are emotionally involved, too often frustration takes over your better sense. And you say, forget it. I'm tired of this. I don't want to do this anymore. Just give him whatever he wants. And that may be how you feel in the moment. That's not necessarily how you're going to feel about it 6 months from now. It is the attorney's job. It is my job as your attorney to say, I understand that you're frustrated, but I am here to think of your long term, not your short term feelings. Your long term success versus your short term feelings. That is what I, as the attorney, am here to protect you from. And the first way to do that is to understand what custody actually means. In New Jersey and in most states, there are two aspects to custody: legal custody and residential custody. People come in all the time saying, Danielle, I want full custody. Full custody doesn't mean anything to me. What does full custody mean? Legal custody concerns decision making. And those are decisions concerning the major life issues involving the child. Those would be medical. So basically your health, education, and welfare of the child. Those are the major decisions. And the law presumes that both parties are entitled to participate in those decisions. Residential custody is where the child lives. Typically, the child lives primarily with one parent, even if they see the other parent maybe on weekends or holidays. So there is a primary residential parent, which is the parent the child lives with. And there is a parent of alternate residence, which is what sometimes is known as the weekend parent. Now, there are various arrangements for custody. Some people, one parent sees the child on the weekends, other parent during the week. Some people are alternating days. You know, the child is with one parent one day, one parent the next day. Some people are alternating weeks so that it's a 50-50 split, 1 week with me, 1 week with you. Custody is very much a case-by-case determination. The law does not favor one gender over the other, contrary to popular belief. What it favors is stability, safety, and the child's emotional well-being. While divorce is about your marital relationship, that is the relationship between you and your spouse, custody is about the parental relationship. That is the relationship of the parents to the child. Regardless of how you and your spouse interact, that does not change the spouse's status as a parent to the child. And it is our job, it is my job as your attorney to present the narrative to the court of your role in the child's life to ensure that your bond is protected, to ensure that the child's best interests are served by the courts, regardless of what the other parent may say or do or be. It is about serving the child's best interest. And as your attorney, it's my job to show that the best interest of the child is to be primarily with you. Now, connected to custody is obviously child support. The parent the child lives with is the parent that is entitled to child support from the other parent. Now, child support is money for the child's expenses, but it's not money to the child. It is money to the parent to help provide for the child. And as such, the support is the child's right, not the parents. Both parents have an obligation to support their children. If one parent is saying, oh, you know what, don't worry about it, you don't have to pay me, I'm good, that may be all well and good. But as the other parent, do not accept that as the end all and be all of child support, because that other parent can at any time go to court and say, I need support from him. And you are not going to be able to say, well, they told me, I was told I wouldn't have to pay support. That wasn't that parent's right to waive. That is for the benefit of the child. You cannot waive another person's rights. And so I always tell people, what you can do with child support is do an in-kind exchange. Listen, I won't pay you child support, but I'll pay the school tuition, 100% of the Catholic school or private school tuition. That's an in-kind exchange. That is something courts will uphold as long as it's in writing. Any agreement whether it's about custody, child support, divorce, alimony, vacation time, any agreement between parties should always be in writing. It is extremely difficult to enforce an agreement that's not in writing. Everybody's recollection of the agreement, especially what by the time you're going to court, is usually diametrically opposed. It needs to be in writing for it to be enforceable. Now, with respect to child support, New Jersey handles child support a little bit differently in that it is not a flat rate. There are some states like New York that will do child support as a flat rate of a parent's income. In New Jersey, it is a shared income model. So the court looks at mom's income and dad's income, the ratio of those incomes, but most importantly, what time is spent with the child. The more overnights a parent spends, the lower the child support obligation that parent will have to uh, pay. But also, it's not just about income. The court also looks at what expenses are already being paid for the child and who's paying it. So, for example, health insurance, who's paying for the child's health insurance? That gets factored into the overall support amount. Is there an extraordinary daycare cost? That gets factored into how much child support is paid because, after all, there's only one pot. All the money's coming out of one pot. And if you're paying the 100% of the daycare and 100% of the healthcare, that's leaving you less money to pay everyday expenses. And as I said before, both parents have an obligation to support their children. Extracurricular activities can also be factored into child support calculations. And when the children get older, college expenses, although there is a slightly different calculation for support for children that are in college. But college expenses is also something that can be requested as part of a divorce, a contribution towards college. Having an attorney represent you means that these issues are thoroughly and properly addressed so that there are no surprises later. If you have a 14-year-old, you don't want to wait until senior year of high school to figure out what are we doing about college. That needs to be addressed in your divorce complaint, in your marital settlement agreement, or any other agreement that comes out of the divorce. Now, one of the biggest fears in divorce is the hidden asset. There is always I've had it actually happen on a few occasions where party came in and was like, I know that he makes X amount of money, but he works for a family business. Or she's not declaring all of her money from her hairdressing business, or she's a nail tech and she owns several nail salons, but she's only claiming to make $600 a week or what have you. That is why in divorce cases, you are required to exchange financial information. One of the required documents in a divorce is a case information statement, and that is the statement where you lay out all of the income, all of the assets, all of the debts, all of the expenses. And as an attorney, that ends up being one of the most important documents in a contested divorce case, because if you can't prove the income, prove the expenses. If you're somebody that is claiming that you only make $30,000 a year, but you're claiming expenses of $80,000 a year, something's not adding up. Because if you only made $30,000, but your expenses are $80,000, there's obviously either a pot of money somewhere else, or you should be living on the street. And if you're not living on the street, then we know somebody is lying. You're either lying about your expenses, or more likely, you're lying about your income. And there goes the deep dive. And the deep dive involves having to provide proof of your bank statements for 5 years, your tax returns for 5 years, your credit card statements for 5 years, so that we can see where is money going, where is it being spent. Is somebody who makes $30,000 a year spending $15,000 flying to Europe? Probably not. Where's the $15,000 coming from? That is what you need an attorney to be able to analyze and provide for you. And in a divorce, there's a process in divorce called discovery. Discovery is when all that information is exchanged. You're literally discovering the details that you don't know, because there are a lot of marriages that where one party holds all the information, whether it's husband and wife. One party is the one paying all the bills, so they know what goes out. The other party is just depositing checks. So when it comes to divorce, they don't know what the expenses are. They don't know who the debtors are. Discovery is where you discover that. That's where you send out subpoenas for information. That's where you send out the request for the case information statement. That's where you send out the what's known as interrogatories, which is a standard set of questions seeking information about more specific information about income, assets, debts, expenses, lifestyle, so that a picture can start to be formed of the marriage, and more importantly, what the entitlement is. Now, everybody's not going to know what to ask. That's why you hire an attorney that will have that knowledge and understand how to get the information that you need to get to ensure that you get everything you're entitled to, because that is the role of the attorney, to allow you to get everything that you are entitled to. Now, as I said earlier, do you need an attorney in every divorce? No. Should you have one? Yes, because it is nobody knows the buttons to push like your spouse. And when it comes to dividing assets and paying out of money, people start to get very, I don't want to say mean, but you see a different side of people. And in the name of protecting whatever they feel they um, deserve, they can get sneaky. And it is an attorney's job to cut through the misrepresentations and the misstatement of fact and tell you the cold, honest truth and fight for you to get what you rightfully deserve. Not what you think you deserve, but what you rightfully deserve. And as a family law attorney for over 20 years, that has always been my fight, to provide the information and the knowledge that you need to preserve and your rights and establish your way forward. And especially if there has been any kind of history of domestic violence. Any history of domestic violence between the parties means the playing field is uneven. One party is a dominant party, the other party is not so much a submissive party, but at a significant disadvantage, a psychological disadvantage, an emotional disadvantage, sometimes a physical disadvantage because of the domestic violence. You absolutely need an attorney to ensure that you are not manipulated out of your rights. And if you at any point in the process are scared of being hurt physically, uh, or being harassed because you are not giving the other side what it is that they want, you absolutely always have the right to file an order of protection. You should always have an attorney represent you in those instances to make sure that you are making decisions from not a place of knowledge and not a place of fear. So if you're ready to move on from that place of fear, that place of uncertainty, and get a representation that will fight for you and your family, please contact the Legal Assistance Center. I've been doing this for 20 years. I've done thousands of family law cases. I've seen every possible variation of family law matters and complications. And I'm here to make sure that you and your family get everything that you deserve, that you're not taken advantage of just because you were not aware. Please feel free to leave me a message. Visit my website, www.tlac-nj.net. That's www.tlac-nj.net. Thank you.